Welcome back to the Elias Macko Show. The new healthcare language directives have been at the forefront of debate for the past week. Yesterday, no different. Lawyers Julius Grey and Eric Maldoff co-penning an op-ed in the Montreal Gazette, and in their open letter, they express how the directives are, quote, immoral and dangerous. With more about why he co-wrote that letter, let's go to Julius Grey, Montreal-based constitutional lawyer, senior attorney at Grey Casgrain. Welcome back to the program, Mr. Grey.
Hi.
So let's talk about what compelled you to write the piece. What do you feel is so egregious here that you had to put pen to paper?
I think these directives are totally immoral because what they want to do is promote a very questionable policy of unilingualism at all stages on the backs of the weakest people, the most vulnerable, those who are ill, those who find themselves in hospital or in retirement homes. I think it's a shocking disregard for human rights.
Can I ask you about the emphatic lines we've heard from government officials? And I'm thinking about Jean-François Roberge, the French language minister. And over the past few days, he's been posting social media, and he's emphatic, right? When it comes to health, here's a direct quote from one of his social media posts. When it comes to health, the government imposes absolutely no language conditions before providing care in English to anyone who requests it. What do you think? Well, what explains how they feel they can be so emphatic that nothing is changing here versus a directive that's written somewhere that, you and others are saying, no, it really does change things?
Well, I think they've been saying that all the way since Bill 96 has started, that in healthcare there'll be no change. And, of course, they're not telling us the truth. One of the problems, of course, there is that Bill 96 and even Bill 101 before that said that an employee has the absolute right to work in French only. That doesn't exist even in Ontario or in England or in France. People do have to use other languages, but in Quebec they want to guarantee the right to use French only. And therefore, when you put in these directives, what you can be sure of is that all sorts of people will say, I won't use English. And therefore, even if it's not directly forbidden, and I think in many cases it is, that's why they want to issue English cards, you'll find that use of English is almost impossible and is opposed by many employees and possibly, unfortunately, by unions. Because in Quebec, unions are not only defenders of the worker, which they should be, but also nationalists.
It's so interesting you bring up unions, Mr. Grey. On this program yesterday, I actually brought up, that sort of stereotype we have of a nationalist separatist union member, and how there may be some of that there on a just on that idea. This is Quebec. I only have to speak French. So for you, a lot of this really does have to do with the employees. It's not necessarily about, patients will pay the price, but this directive, more about employees than patients.
I think this directive is part of the whole trend. The present government, the CAQ government, is determined to make French the only language and to maintain the exceptions for the minority in the narrowest possible form. So they have the notion of the historic Anglo, which is nonsense. And nonsense, especially when people are ill in hospital. Are you historic or are you not? What we've got is a nationalist policy that transcends everything. And I always thought that in Canada and in Quebec, human rights transcended everything. If Quebec did not sign the original Canadian Charter, it did pass the Quebec one. And so those are the transcendental values of Quebec society. But now it appears that national policy, nationalism, unilingualism trump everything. And I think that's just plain wrong. And they should not be playing politics either in the hospital or in old people's homes or in clinics or anywhere like that.
With constitutional lawyer Julius Grey talking about the healthcare language directives. So on this program yesterday, we spoke to our listeners. I was asking them their stories about the healthcare system and the language they're served in. I got to say, the vast majority of people, and I was getting stories about people that were in ERs, French system ERs, saying they got unbelievable care in English. You know, I've gone through the system the last few months with family and baby and that kind of stuff. Always got my care in English. But I did get a call from someone who said, you know, my doctor, pre-96, post-96, now telling me they won't serve me in English. So I guess the question I have is, what needs to happen here with actual cases of people saying, hey, I can't get care in English anymore, in order to move on a legal front against this directive?
You know, I don't think your doctor will say I won't serve you in English. I think most Quebec healthcare workers are much more conscientious of that. Doctors, nurses, and so on will continue to use English when they can. But what you're going to have is complete insecurity about it. You won't be able to be sure. And the doctor or the nurse will usually do so, but you could face a situation where somebody is going to say, do you have your card? People will feel less welcome and less secure.
Are there legal avenues here to go down when it comes to this directive and fighting against it?
Pardon me, I didn't hear you.
Are there legal avenues that need to be taken right now?
I think a directive can be challenged. Now, I do believe there is a challenge. First of all, directives are not law. They're sort of promulgated, they're guidelines, but they're not law. And I don't think the notwithstanding clause necessarily applies to a directive. In other words, they could be challenged on constitutional grounds. They could also be challenged on administrative law grounds because nothing in the law itself, not even in Bill 96, provides for this type of health care thing. So I do think there's room to fight it. The question is the cost and the delays right now, because, as you know, the challenges to Bill 96 are still in the early stages, and it's very difficult to get them heard. It's in motions and discussions and deposits of exhibits. So, yes, there are legal remedies. I hope they will be taken sooner or later. But it's not something that's easy or affordable.
And would you need to have concrete examples of care that was denied, not offered, before you could move forward with a legal challenge?
I think you could do a declaratory judgment on the directive, but I'm sure the government would object to it. It would try to pretend that you need a direct interest. I think that procedurally people could challenge it in advance. You don't have to have a refusal in order to challenge it because it creates an insecurity, whether or not it actually is challenged.
And, of course, we're talking a lot about English and French here, but I'd be remiss if I didn't bring up, we have an Italian hospital, Chinese hospital. You think about all the cultural communities in Montreal, immigrant groups. I'm sure there are people that need services in Arabic and other languages, right? Does this?
Well, I think a normal doctor, if he speaks a language, will serve somebody in another language. I know that I talk to clients in languages other than English and French. So yes, it affects everything. And one thing that must be made clear, it in no way protects French. The argument that French is in danger, which I think is wrong anyway, but the argument that French is in danger does not assist this type of directive, because you can't imagine how French would be advanced by somebody not getting medical services. It's just completely irrelevant and basically just mean and wrong.
Mr. Grey, it's always a pleasure talking to you. Thank you so much for joining us this morning.
Thank you.
Julius Grey right there, Montreal-based constitutional lawyer, senior attorney at Grey Casgrain.